We've already talked about what the purposes of sentencing are. You might remember those. There's retribution, there's specific deterrence, there's rehabilitation, there's general deterrence, there's reparation. There's a whole bunch of them, right? And so those are dictating what a judge is supposed to be trying to do when it falls to him or her to deal out a sentence in the criminal system. But we haven't really talked about what those sentences actually are. So let's jump straight to the point. We realize we're at the end of the trial. You've either pled guilty, which is much more common, or in other cases, you've had a trial and you've been found guilty of the crime. Now, suddenly the court doesn't treat you the same way. You no longer benefit from the presumption of innocence. The judge kind of talks to you in a different way, starts being much more serious in condemning you for what you've done. And sometimes at this point, after your initial trial where you're found guilty, there was all kinds of evidence that wasn't allowed in because it wasn't important to establishing whether or not you did the thing. But now they might have another little mini trial at this stage where they bring in evidence that was inadmissible for your trial in order to try and tell the judge information about you. Because even if it wasn't important to determine whether you were guilty of the crime, it's important for the judge to have this information about you for the sentencing process. And that's because the judge has a lot of questions that he's trying to answer, right? He's looking at what's happening, saying, okay, what do I know about what the law says about this crime compared to other crimes you might have been convicted of? How bad are the specific details of this incident? Which purposes of sentencing that have been set out by the Supreme Court are most important in your case? How has this guy been sentenced in the past? Is this a recurring or growing problem in this community that requires some kind of loud denunciatory sentence? And most importantly, the biggest question that the judge is asking before sentencing you is, who is this person I'm sentencing? Because judges are really supposed to find out what they can about why you've done what you've done and what punishment is going to be best for, not just for your crime, but for you specifically. It might mean that the judge will order what's called a pre-sentence report, where somebody, often a probation officer in practice, will end up putting together a document that tells the judge your life story. This is especially frequent if you're a non-habitual criminal, if you don't have a criminal record, and the judge wants to try and figure out what is it about this crime, what it is about these circumstances that had you, somebody who didn't have a criminal record, all of a sudden commit a crime. And it's actually mandatory if a judge wants to send a young person to jail. When we look at the Youth Criminal Justice Act, we'll talk more about that. Because implicitly, a young person, we really want to know what's going on in their life that they've committed a crime. Now, the factors in a person's life that a judge is going to be watching for, they're going to be watching for if you have a lack of structure in your life that they feel that needs to be addressed. They want to know what potential there is for rehabilitation with you. They also want to know to what degree you're actually remorseful legitimately about the offense in question. They want to know all this. And they especially want to know if you have any previous convictions, because these will play a significant role in determining your sentence. If you've got a long history of being punished for something, they're going to recognize, all right, well, that punishment didn't seem to work the last time, so it looks like I need to bring it to a higher level with you. Now, there may also be, as part of the whole sentencing process, the fact-finding process before sentencing you, there may be a victim impact statement. This is pretty recent in Canadian law, relatively speaking, and it can be a bit problematic in that there's no cross-examining of what the victim says here. So any important facts that come out of the victim impact statement are not really supposed to be relevant for their factual value. It's more just to find out about the emotional state of the person. But sometimes some stuff comes out in the victim impact statement that can't really be challenged, so it can be a bit awkward in some cases. The judge also asks the accused if they have anything to say before the sentence is determined. Most criminal lawyers will tell their clients it's better if you don't say anything, because most criminals tend not to be very good at expressing themselves. They tend to try and minimize what they've done, which usually doesn't go over very well with the judge. But if you have a student who's very good at expressing himself in Loyola speech class, then when you do get convicted of a crime, as is almost inevitable, then that skill will actually serve you in pretty good stead for convincing a judge maybe that you have some potential for rehabilitation. Now, when the judge gets all this information together, the judge has to craft a sentence for the specific crime and this specific criminal. In the vast majority of cases, when they're looking to the criminal code for guidance as to how they're supposed to do this, the criminal code will set out a maximum sentence for the crime you've been convicted of. It's pretty rare that they'll give you a minimum sentence. When there is a minimum sentence, actually a whole different kettle of fish, and it really limits the judge's discretion as to what sorts of sentences the judge can give out. But usually the judge is looking at the maximum sentence. And it's actually the case that it's very, very rare that a judge will sentence somebody to the maximum sentence in the criminal code. It's extremely rare. So you might be wondering, well, if the maximum sentence pretty much never gets used, then what's the point of having it there in the criminal code? Well, it's because even if the judge doesn't use the maximum sentence to nail you, it's still, the judge is looking at it to determine how Parliament is telling the judge how seriously that offense needs to be punished relative to other ones. Because the maximum is kind of how Parliament communicates to judges what we call the relative gravity of the offense. If you compare the different maximums of different kinds of crimes, even if those maximums don't get used as actual sentences, it tells you how severe one crime is relative to the other. This makes a lot more sense with an example. Let's say, for example, we're looking at simple assault, right? That's not assault causing bodily harm. There isn't like broken arms or anything like that. Simple assault in the criminal code has a maximum sentence of 5 years. The maximum sentence for theft of property valued at less than $5,000 is 2 years. If it's worth less than that, then that's all the judge can give you. Unless, even if it's worth less than $5,000, a stolen motor vehicle of whatever value allows for a maximum sentence of 10 years. So with all that, even though you don't see a judge sentencing somebody to 5 years for assault, or 2 years for theft of property under $5,000, or 10 years for stealing a motor vehicle, we can conclude from all this that Parliament wants the judge to understand that assault is more serious than shoplifting, but not more serious than car theft. Car theft is more serious than assault. How do we know? Because Parliament is telling us this through the maximums in the criminal code.